application in the matter of Charlie Gard.
Before we begin, Mr. Gordon, the court has been asked to make an anonymity order, not, of course, to protect the child or his parents, but to protect all the medical, nursing and other professional people involved in the case. And it is understood that there are no objections to the court making that order.
My lady, the position is, from our point of view, we have no objection to the order being made or to the order not being made. That is our position.
You're neutral?
Yes.
Yes. Obviously, the respondents are in favour of the order being made because it's the first respondent's application. And therefore, the court will make the order in the terms which I will read out so that people understand what it says. No one shall, in connection with these proceedings, publish or reveal A, the name and or address of the hospital in the United States of America from which treatment is sought, B, the identity of any potential treating doctor at the hospital in the United States, C, the identity of any of the treating medical staff, doctors, nurses or others at the current treating hospital in the United Kingdom, D, the identity of any of the second opinion doctors, E, the identity of the independent paediatric neurology expert, F, the identity of any of the medical research staff at the institution in Spain which provided an opinion on whether or not to offer the treatment, G, the identity of the guardian, H, any picture of any of the above, or publish or reveal any information which will be likely to lead to identification in connection with these proceedings. Paragraph 2 reads, nothing in this order shall prevent any person from A, publishing information about the second respondent and any medical condition of his and any proposed clinical method of treatment or management of his condition, B, publishing information contained in any public judgment given in this case, C, subject to any order made in proceedings under Section 11 of the Contempt of Court Act 1981, publishing information relating to any part of the proceedings before any court other than a court sitting in private, and in particular publishing a full report of or any part of any coroner's inquest held in public. D, publishing information which does not contravene paragraph 1. E, inquiring whether a person is protected by this order. F, seeking information relating to the second respondent while exercising any function authorised by statute or by any court of competent jurisdiction. And G, seeking information from the first respondent's solicitor or CAFCAS. That is the order that we now make.
I'm very grateful, my lady. May I deal first with representation?
By all means.
I appear for the appellants, Constance Yates and Christopher Gard, who are the parents of Charlie Gard, together with my learned friends Mr. Grant Armstrong, Mr. Gerard Rothschild, and Mr. Andrew McIntyre. The Great Ormond Street Hospital for Children NHS Foundation, the first respondent, is represented by my learned friends Miss Katie Gollop and Miss Susanna Rickard. The second respondent, Charlie Gard, acting through his guardian, is represented by my learned friends Miss Victoria Butler-Cole and Mr. Benjamin Tankle, and my learned friend Mr. Alan Payne appears for, as I understand it, Her Majesty's government. Whether his attendance will be needed or not remains to be seen, but he's here, and I know that your Ladyship's aware of that.
We are aware of that. We were grateful for the Government Legal Department's offer to send somebody along to this hearing in case
Yes.
They could be of any assistance, depending upon how matters turn out.
Of course. Now, I wouldn't normally go through what your Ladyship and Lordship should have, but this hearing, for which we're very grateful, being convened so quickly, has brought together a mass of bundles. So let me just say there is one appeal bundle, quite small, which contains the grounds and skeleton arguments of all the parties. There is what I will call a hearing bundle, which is the bundle of documents that were present before the learned Judge, Mr. Justice Francis. There is a supplemental bundle of transcripts, And then perhaps most appositely, if we need any of them, there are 3 bundles of authorities from us and 1 supplemental bundle of authorities from the respondents. And finally, though I don't think the court will have this, but I'm just going to mention it, we have loose copies of the 1 respondent's notice that was served in the Court of Appeal, which may or may not be potentially material.
Well, as you are aware, Mr. Gordon, this is a hearing of your application for permission to appeal.
Yes.
It's not normally the court's practice to look at authorities on permission applications.
Absolutely.
And indeed, most of the authorities to which reference has been made in the courts below, we're all very familiar with.
Absolutely. They're here out of an abundance of caution, but I'm probably not going to mention any of them. So, subject to the court's approval, what I was going to do was say a few very general words about the case, then to identify 7 core propositions. These are abstract propositions which we say govern or should govern the way in which the court approaches a case like this, then to address specifically your ladyship's and lordship's provisional views. And there was a 4th part of it, but I could see your ladyship looking at the clock, and I certainly don't want to take up too much time on what is obviously a short permission application.
Well, we understand it's a very, very serious case, and it matters a great deal to more than 2 people.
Yes.
And so we obviously don't wish you to be rushed, but equally, our normal practice is half an hour for permission to appeal oral applications.
It's a slight tightrope, but I'll do my best. My lady, may I first of all say that in our respectful submission, there is a single question of principle which is of the utmost importance, not merely for, or not only, I should say, for family law, but more generally. As far as we can detect, this question has never been considered by a court. It has implications extending well beyond the exceptional facts of the present case. The question is the extent to which the state, and by this I include, and in fact primarily mean, the court, may legitimately intrude into private and family life in the context of parental decisions, and I want to emphasize the word decisions, that but for the court's intervention, parents would be able to make and would be completely free to make in respect of their child. At the heart of this proposed appeal, as the court's note very helpfully implicitly underlines, is the question of what is properly justiciable. At paragraph 4 of our skeleton argument, we suggest that questions of upbringing should generally not come before a court. If a statutory issue can be created simply by a party approaching the court and raising questions as to what is in the best interests of a child, that would erode the whole concept of parental responsibility. In fact, it would shift the responsibility from parents to state. And more widely,
You make that proposition on the assumption that the parents are agreed.
I do, yes.
Because those questions come before the court all the time.
Absolutely.
Parents disagree.
And it fits absolutely into my schema to say that where parents are not agreed, the court must intervene. And I'll explain why it's not an exception to what I'm suggesting. It's a necessity that the court would in that situation intervene. But more widely, if the state can, without the highest of justification, intrude into so private an area of human life as a joint parental decision made about one's child's or children's upbringing, the scope for protection against state interference afforded by our most basic constitutional values, as well as by Article 8 of the European Convention, is considerably eroded. That's why the point is so important. It goes beyond, as I say, family law. Now, the specific issue on the facts is whether or not the state may permit the life of a now 10-month-old baby to be extinguished in particular circumstances. Those circumstances are that the baby, Charlie Gard, is undoubtedly suffering from a life-threatening and almost certainly terminal illness. But his parents, Connie Yates and Chris Gard, have made a decision. It's not a wish, it's a decision to try to keep all options open to retain life for their child and to improve what remains of his life by transferring him from the custody of a reputable hospital where the clinicians do not feel able to continue treatment, into the custody of an equally reputable clinician in the United States who is willing to try a new, and we accept, highly experimental treatment which he expects to be beneficial. And in a sense, it is a choice of treatment. The parents want to try the treatment that is being offered to them, and they have raised funds to be able to afford that treatment. If freed from the custody of Great Ormond Street, where we say he is being deprived of his liberty, Charlie would receive nucleoside bypass therapy, which I'll henceforth call NBT. It is a wholly non-invasive treatment. It is administered into food by a powder, and as I've said, it is certainly experimental, but Dr. I, the doctor who would be responsible for Charlie's treatment in the United States, says, and has said very clearly, that he expects that NBT would be beneficial. It is implicit, though not explicit, because he was never asked the question in the High Court, that he does not consider that NBT would cause Charlie significant harm. And indeed, we would suggest that he does, by virtue of his opinion, clearly believe that it would be in Charlie's best interest to have this treatment. Three things are, we suggest, common ground. First, these are model parents trying to do all that they possibly can for the benefit of their child. Secondly, they would not willingly do anything to cause Charlie harm, still less significant harm, any more than would Dr. I. Thirdly, their view of what is in Charlie's best interests differs from that of the High Court, and indeed that of the Court of Appeal. The specific question at the heart of this proposed appeal is therefore whether the state has the power to intrude on the decisions the parents have made to so massive an extent as to be able, by order of the court, to mandate that child's death before his life needs to come to an end. An order, it must be said, designed not only to permit GOSH, as I'll call them, Great Ormond Street, to withdraw treatment, but also to prevent the parents from giving effect to their decision to take Charlie to the United States for alternative treatment. It is, we respectfully submit, surprising that at no stage, from GOSH's application to the High Court, through the legal argument and judgment in the High Court, to the judgment of the Court of Appeal, has there been any analysis of, or even mention of, the fundamental rights that drive the core legal issue. Whether those rights derive from the European Convention or from our domestic constitutional values, we say that there is a boundary beyond which the state, and here I include GOSH as well as the courts, simply cannot go without the strongest justification. The state is not, we say, entitled to cause a child's life to be extinguished in the way that Mr. Justice Francis's order does. May I now set out our 7 propositions? Proposition 1.
Could you just remind us all where we find his order?
The order, yes.
Rather important. I think it's tab 14 of the bundle.
It is. It's tab 14. And it's a series of declarations. And cutting that very short, it, on one level, read syntactically, Declaration 4, is that a declaration that it's not in Charlie's best interest to travel to America for NBT. And the effect of that declaration, and indeed the intended effect, and I can take the court, if necessary, to the transcripts of the hearing, it's quite clear that order was intended to have the effect that Charlie's parents could not remove him from the hospital. But may I now set out...
There was, in fact, no injunction to that effect.
No, it doesn't matter. That was what was intended. Indeed, I can take the court to the transcript of April the 5th hearing, where the judge himself is slightly concerned that Connie Yates, the child's mother, did not know that this was an application designed to prevent Charlie from going to the United States.
Is there a distinction to be drawn between something which is not in the child's best interests, on the one hand, and on the other, a decision that to permit a particular course would emphatically not be in his best interests?
There's no, as far as I'm aware, best interest is a particular construct, and all the cases deal with it. A test beyond that, a boundary line beyond that, has never been articulated by the courts. We say that that boundary line lies in the concept of significant harm, Your Lordship, I think, has just articulated a possible halfway house, but the point is nothing has ever been treated by the courts as going beyond best interests. And the reason...
However a case comes before the court, if the court is persuaded by the evidence with which it is presented that to permit a particular cause sought by the parents of the child would, well, first of all, be harmful to the child, then it's surely permissible for the court. In fact, it's required of the court that they take action to prevent that happening.
I think there's a great danger here, my lord, and I'm going to state what the danger is of begging the question to be decided. It's very difficult. It will emerge from these propositions, but the great danger is that one must stop at the threshold jurisdictional question. We have at least three players in this, three participants who might decide where a child's best interests lay. One is obviously the treating clinicians who may have to make a decision as to, in terms of their own ethical obligations, what they can lawfully provide. They will usually come to the court for a declaration in relation to that. There are the parents who have to exercise parental responsibilities. They're not rights, by the way. Some of the skeletons and arguments below talked about rights. These are responsibilities. And then thirdly, there's the court. Now, there is nothing intrinsic in the proposition that best interests has to be decided by a court. The reason why best interests has been, in so many of the cases decided by a court, is that there is a justiciable issue which the court cannot avoid deciding. And indeed, my Lady Hale, having mentioned, for example, the split parental problem, but there are many others. The dispute normally comes before the court where a clinician is saying, I cannot continue treatment, or I want to provide this treatment. The court is necessarily in that situation an adjudicator. But the court, in my respectful submission, cannot go beyond that adjudicatory role and actually simply say any question relating to a child's welfare is to be decided by a court. I'll explain why I say that in a moment. May I now set out the proposition?
Yes.
Because this is a more structured way of approaching it. So we say Proposition 1, from first principles, whether founded on the European Convention on Human Rights, Articles 2 and or 5 and or 8, or our own constitutional values, there must be a clear boundary line between decisions that a parent may, indeed must, as part of their responsibilities, make in the discharge of their statutory responsibilities, and we call those Category 2 cases, and those decisions that may indeed must legitimately be taken by the state, however much parents may disagree with it. And we referred to that below as a Category 1 case. So that's our first proposition. The second proposition is that the boundary line, if you accept there has to be a boundary line, cannot be that of best interests. If best interests were to be the relevant touchstone, the distinction between legitimate state action and the discharge of parental responsibility would disappear, since any action by parents with which the court disagreed could be overruled, could at the suit of any person be overruled. The third proposition is that if the first two propositions are right, it follows inevitably that there must be a further boundary line in respect of that which is justiciable by a court in relation to a child's welfare, including upbringing. That follows inevitably from the fact that, if it's accepted, that the boundary line cannot be that of best interests. Point number 4, the only sensible boundary line that can be drawn, and that has in other contexts been drawn, is that parents are free to discharge their parental responsibilities by making decisions in respect of their child, unless the purported discharge of those responsibilities would be likely to cause their child significant harm. Let me pause for one moment just to draw the analogy with wardship proceedings, where local authorities under Section 100 of the Children Act have to pass the significant harm threshold. And of course, Mr. Justice Baker, in the case of Ree King, referred almost axiomatically, as if it were an axiom, to the concept of significant harm. Proposition 5.
It is, of course, the case that until the Children Act introduced Section 100, local authorities were free to invoke wardship
Yes,
whenever they wanted to.
absolutely. And indeed, those were the days before perhaps we had a European Convention on Fundamental Rights. Proposition 5. These propositions are distinct from the Category 1 case.
I'm sorry, I've only got down to 4. What was the fourth?
4 was the only sensible boundary line that can be drawn and has in other contexts been drawn.
Oh, that's number 4, is it?
That's number 4.
Yeah.
Sorry,
No, I had significant harm down as part of 3.
I see.
Sorry about that.
Proposition 5. These propositions are distinct from the Category 1 case, where notwithstanding parents wishing to make decisions in respect of their child, it is not possible for them to do so without a court order, a court ruling on a child's welfare. Proposition 6. The only sensible touchstone for the court making decisions of that kind, that's the Category 1 case kind, is the best interests of the child, and that can be reconciled and is consistent with existing case law. In such a case, parents' wishes, and they're not making decisions in such a case, parents' wishes cannot be in any sense determinative. But in such a case, the state is not violating any fundamental or constitutional rights in the child or the parents. A decision has to be made. Take the clinician-parent case. The parents can't force the doctor to treat. They cannot make a relevant decision. The parents in this case, the parents in the King case, had made decisions. And as Mr. Justice Baker put it, perhaps somewhat graphically, the state, the court, had no business in interfering with those decisions. Obviously, the parents can't make any decision because if they go outside the bounds of any kind of sensible parental responsibility, there has to be some measure of state control. We accept that. The final proposition, but where the threshold test for justiciability is one of significant harm, the Category 2 case, it is, we say, logically incoherent and therefore unlawful to apply a best interest test. The threshold for a lawful finding of significant harm is necessarily higher than for a best interest finding. In order to ensure procedural protection of the relevant convention rights, there would and must, in consideration as to whether there is significant harm, have to be, 1, proceedings directed towards establishing significant harm by reference to clear legal principles, and 2, evidence given in respect of that issue and directed to that issue.
But there can't be hermetically sealed compartments between best interest and significant harm, can there? The question of best interest must have some relevance and contribution to make to the decision whether there is significant harm.
It can't overlap completely. And the reason it can't overlap completely...
No, I'm not suggesting it overlaps completely. What I'm suggesting is that there must be a best interest ingredient in the examination of whether significant harm has been established.
You couldn't possibly have significant harm where it was in the best interests of the child to have something different happening. I fully accept that. But the problem is here, what's happened here in a nutshell, and I'll explain it why it's happened and how it's happened, is that the Court of Appeal has simply taken from royal guidelines a whole mass of stuff on best interests and transposed it to this case. And that's why we say we're not stuck with the factual findings against us. And I'll come back to that.
Well, you'll have to come back to that.
I'll come back to that.
If I've understood your propositions correctly, it is the logic of your final proposition, in fact, of all of them, that absent a likelihood of significant harm, parents are entitled to impose upon their children, or to refrain from imposing on their children, things which are not in their child's best interests. They are entitled to treat their children otherwise than in accordance with their children's best interests.
Your ladyship has skipped one element.
I mean, you may be correct. I'm not saying that you're not correct.
I think, and I'm in a case like this with so little time and so important, I may be wrong, but I think the flaw in that question, if I may respectfully put it, is that it's assuming that what a court says is in a child's best interest is in a child's best interest. In other words, what I'm putting up as equally relevant to a court decision on best interests is the parental responsibility evaluation of that concept. And what I'm suggesting is that, and Lord Justice McFarlane in the Court of Appeal had this, in one sense, absolutely at his fingertips, which is the parents listen to the child. They may not have guidelines in front of them, but they know. And they know they can make mistakes, but they know what is in the child's best interests. That's what you're saying, isn't it? I mean, that was what we were saying. Parents can make a legitimate decision. A court may not agree with it, but if and once one says that parents have the freedom to make that decision, and it's entirely consistent with convention law, the only other possibility way into the problem is to say, oh, no, you never have that decision. You never have that decision to make. It's always for the court ultimately to make that decision. And once you draw that conclusion, you are into quicksand. And the reason you're into quicksand is that the distinction between parental responsibility, what a parent can decide, is subject to the supervisory control of the state in every single aspect. That's the logical problem here. And what every court has so far done, in my respectful submission, is to assume that, well, if the parents can make a decision absent significant harm, they must be controverting their child's best interest. That's only if you accept the premise, which we don't accept, and which is at the heart of this appeal, that the best interest has a juridical stamp on it. Now, we say that is the whole point, and that is the whole point of convention protection here. If you look at L, and I won't take you to L, but it's in our skeleton, Mr. Justice Headley, talking about the state and talking about parents can make mistakes. We all know they can. But how close are we to a state control of anything a parent can do if the respondents are right in this case? So that's at the heart of this appeal. And it's so important because unless we are right, it is a litmus paper test of the lack of protection, ultimately, of Article 8 in terms of protection against state control. That is
a dramatic moment when you said, in answer to my lady, we can't assume that what a court says about best interests is best interests.
It's always best in every context.
I can't assume it.
Can't assume it. For this reason.
Does it follow that when the trial judge has declared in his order that it is in Charlie's best interest not to undergo nucleoside therapy,
yes,
that we can't work from that?
No, you can't work from that, except, and this is the proviso, this is where it's so important, the court, I suppose it's render unto Caesar what is Caesar's, the court has its own remit. Within that remit, the court decision will be absolute. The remit here, the only remit the court had, at the suit of the clinicians that brought this case, is the validating jurisdiction to say that particular treatment or withdrawal of treatment is or is not lawful. And that will, of course, embrace consideration of the best interest test. So as between treatment that Gosh was lawfully entitled to give or lawfully entitled to withdraw, the court's ruling, the court's declaratory ruling, would operate to validate that which Gosh did. What it would not operate to do, and this is really important, is to invalidate the parental choice to say, okay, we accept that. Actually, it was never an issue because the parents were not trying to force Gosh to do anything. We want to choose the treatment to keep our child alive and to take it to America. Gosh, in our respectful submission, and I don't want to appear to be critical because it's terribly easy in these cases to raise the temperature, but what Gosh is doing, or has been doing, it goes way beyond that which a treating clinician can do, if we're right, in terms of legal justiciability before the courts. Gosh is perfectly entitled to say, our clinicians cannot continue to perform this treatment. We don't think it's in Charlie's best interests. And the court will say, having considered the evidence, having gone through the usual balancing exercise, we agree with you. That's it. If that were
how can you say that the hospital has exceeded its proper remit? It has laid a problem before the court.
Yes.
And the court has dealt with it.
It's laid the problem.
What was wrong about that?
It's laid the problem. It actually hasn't laid. The reality of this case is that although the original application was an application by Gosh to say we want to withdraw ventilation. Is it lawful to do so? It went beyond that at some stage and morphed into going beyond a legitimate action that Gosh wanted to take to saying not only do we want our own action validated, but we want to prevent any other doctor treating Charlie. That's the effect of what we want. We, the parents, want to take Charlie away from a hospital whose clinicians don't think it's in his best interest to conduct that treatment. We're not allowed to do so. May I just remember...
Let Mr. Gordon, this business of hospital preventing,
Yes.
let's be quite clear. It is so far, insofar as there has been a prevention, and de facto there has,
Yes.
it has been the court that has prevented. And I really think that for you to be saying that the hospital has prevented is a distortion.
Well, I did want to say to your lordship, and I recognise the danger of words I was using, that I did not want to heat the temperature. But the point is this.
Well, quite.
But may I just indicate, as I must be equally responsive to your lordship, as well as accepting the danger that words can bring into this case, there is no doubt that this was an application which, at the time of the hearing, was an application to prevent Charlie from going to America. And I can show your lordship the passages in the transcript which show that. So, although I don't want to suggest for a moment that Gosh has some mission to stop the child going, I'm certainly not saying that, but that was the purpose of the application before the court. And I can show the court that if you want to see it.
But does it now matter? As my lord has pointed out, it's the effect of the order of the court which prevents Charlie from going to America.
Yes, I wouldn't shrink for a moment from saying that the proximate cause of Charlie not being able to go to the United States is the court order. I have no difficulty in accepting that. But of course, for a court to make an order, which, if we're right, the court ought not to have made, is to go beyond its jurisdiction. But it can only go beyond its jurisdiction if it has in front of it proceedings which it is in the course of adjudicating on. And we say these proceedings, at the time they were brought, should not have been continued. We definitely do say that. And I'll show you the transcript in which it is clear that that was the purpose of the application.
So basically what you are saying is that those who are currently looking after Charlie, and have been doing so for a very long time now,
Yes.
are not entitled to have a view about whether alternative treatment is in his best interests and to put that view before the court. They're not entitled to do that.
They're entitled to have a view about the alternative treatment. What they're not entitled to do is to bring proceedings, the intended effect of which is to prevent Charlie from going to the United States.
We've been through that. They brought proceedings with a view to validating their own decisions in relation to Charlie. You have said that the proceedings morphed into
Yes.
proceedings about whether instead he should go to America.
Yes.
Fine. But I was asking you, are they those proceedings being on foot, there being a lot of evidence before the court?
Yes.
Are the hospital not entitled, as the people who've been looking after Charlie and who know him professionally and no doubt personally, are they not entitled to have a view
Yes.
about what is in his best interest?
Of course.
And to put that before the court?
Well, insofar as they are putting before the court a view about treatment which they do not want themselves to administer, they can put that view before the court. But what they can't do, and what the court can't do, is to then look at the issue beyond the legitimate province of the dispute. In other words, the clinicians can say, we don't think this treatment works for Charlie. We've actually looked at it, and to be fair to Gosh, they did look at it. And the court can consider that view, and in the light of all the evidence, can say, give declarations which allow Charlie not to be treated by Gosh via an NBT treatment. Certainly all that can happen. We accept that. It's when the court goes beyond that, and to that extent I certainly agree with Lord Wilson, that it's the court that makes the order that leads to the problem. I fully accept that. Now, I'm not sure I got beyond Proposition 1. I just want to to check whether I did. Proposition 1 is, it's true.
Well,
I did the 7 propositions. I was now going to turn, I'm very sorry, to our response to your provisional views. I don't know if that's a helpful way of proceeding, but it may
up to a point, the way in which you've put your propositions do provide a response, which is why I asked you the question that I asked you.
Yes. But, my lady, can I then just go through the provisional views and explain our response to them? Mm-hmm. So, point number 1, it is true, see paragraph 1 of the provisional views, that the Supreme Court has to accept the judge's findings of fact as to best interests, insofar as they affect any dispute with which the judge was legitimately concerned. That is to say, any Category 1 dispute between clinicians and parents over what treatment GOSH was required to provide, or GOSH was entitled to withdraw. However, point number 2, if our analysis is correct, those findings are irrelevant as far as a Category 2 case is concerned, including any finding that it was not in Charlie's best interest to travel to the United States of America. The whole question on our analysis is whether parents are entitled to decide what is in their child's best interest in a Category 2 case, subject to a spectrum of permissible decision-making that stops at significant harm. Our point number 3 relates to paragraph 2 of the Court's provisional views. Paragraph 2 of the provisional views, as paragraphs 3 to 4 make clear, is dependent upon whether the proceedings before Mr. Justice Francis were properly constituted, that is to say, justiciable. If we are right, those proceedings were not properly constituted or justiciable, that in turn is, we accept, reducible to the significant harm test, which is set out in paragraph 5 of your provisional views. Point number 4, the Supreme Court accepts, see paragraph 6, at least provisionally, that we have raised a question of general public importance. Point number 5, the 2 difficulties that the Supreme Court identifies in paragraph 6 are only difficulties insofar as our analysis is not accepted, or is not accepted to be arguable. Once the analysis is accepted to be arguable, the difficulties fall away. The first difficulty, I'm on point 6, the first difficulty, the absence of a statute, is no more a difficulty here, we say, than in any case in which the common law resolves questions, with or without the additional assistance of fundamental rights, where a particular issue has not arisen for prior consideration. Once that issue has been considered and resolved, it forms part of the developing common law. If there is no justiciable issue before a court, it follows that no relevant issue has arisen under Section 1 of the Children Act or otherwise.
You refer to the absence of a statute. Mr. Gordon, I was wondering whether, instead of invoking the inherent jurisdiction of the High Court, the hospital might have applied for leave to apply for a specific issue order under the 1989 Act.
They did.
They did?
They did, yeah.
So it wasn't dealt with in that form?
Well, it was dealt with, I'm not quite sure how it was dealt with, but it was dealt with as a conventional best interest case, whether under, I think it's Section 8 of the Children Act, or under the inherent jurisdiction. We say under either source, it's not justiciable.
But, I mean, the Children Act couldn't be clearer that where there is a specific issue order application, the criterion will be the best interest, the paramount consideration will be the best interests of the child.
Absolutely.
Now, how can you escape the logic of that?
Easily. We say that you don't get into Section 1 because there is not a justiciable issue. There is no issue over welfare. Otherwise, if we're not correct about
No issue over welfare?
Exactly, in relation to going to America, because there is no justiciable issue. The proceedings are not properly constituted, and the reason for that is very clear. You have to read the words of Section 1 of the Children Act. You have to read through the lens of Section 3 of the Human Rights Act. And if we're right, and only if we're right, I fully understand that, one cannot bring every issue over welfare over the exercise of parental responsibilities before a court. There are many issues, such issues you can bring, but any issue, if we're wrong about this, can be brought before a court as a welfare issue. Anybody can take a case to court over any exercise of parental responsibility.
Well, that's putting it a little bit strongly, because the people who can make applications for Section 8 orders are laid down by the Children Act.
Well, I'm not sure. Well, your ladyship says that. We've been looking at that. I think you've probably got to have a genuine interest, but I'm not sure how much further than that it goes.
You do have to have permission if you don't have certain specified interests.
But the question really is whether you treat this as a convention question or a question of statutory interpretation doesn't really affect our analysis. If our analysis is correct, there are limits, both constitutionally, I haven't come to that yet, but both constitutionally and under the Human Rights Act, which draw a line at that which the state can legitimately exercise supervision over. And that is where this case is so important, because we say the boundary line has to lie somewhere in the vicinity or the territory identified by Mr. Justice Headley in the L case. And that is, it's such an important passage that he cites. I will show it to the court a little bit in a moment or two. But that's our position, whether it be statute or anything else. So we say there is not a difficulty, there is not an insuperable obstacle to arguability, let me put it that way, by the existence of Section 1 of the Children Act, or indeed the wide inherent jurisdiction of the court. The analysis works either way, and certainly it's arguable that the analysis works either way. We may have to do more work if we were given permission to develop the argument. But that is our argument. My Lord, may I come to our point, I think it's point 7 here. Here we say that the Category 1 and Category 2 distinction is absolutely central to all the convention rights that we have identified. Article 8 is perhaps of particular relevance in this respect. Without a boundary of the kind we seek to articulate between best interests and significant harm, the parents lose all rights to select what is in their perception of their child's best interests without the fear of state intrusion. It is state intrusion on a massive scale. And it is not state intrusion which any of the case law so far has had to deal with. If the answer at the end of the day is that we are wrong in our analysis, what it needs is a principled series of judgments from this court explaining why we're wrong. With great respect to the Court of Appeal, Mr. Justice Francis wasn't faced with this issue. There is absolutely no analysis whatever of the distinction between Category 1 and Category 2 cases. All that the Court of Appeal has done, and I'm sure that this court will have read the judgments, is to recite the best interest cases as if that was the answer to our submissions.
Well, your Category 1 and Category 2 is a construction of your own. It may or may not be an accurate construction.
Absolutely.
But that's what it is. You are using it as an argument to say there is this distinction between these two categories of case, and in one category the court has jurisdiction, in the other category it doesn't. That's what you're saying.
That's what I'm saying. And in order to erode that distinction...
Almost a circular argument.
In order to erode the distinction, no, it's not circular for this reason. If the distinction is wrong, we need to know why it's wrong. All I'm saying is there is nothing in the Court of Appeal judgment that explains why it's wrong. The fact that we have constructed it doesn't mean it's wrong. Mm-hmm. And actually, it's too simplistic to say that the distinction is all the cases apart from Ree King and our case, see paragraph 56 of the Court of Appeal judgment. The point is this problem has not arisen before. So one's got somehow to explain whether the principles to be applied should be exactly the same as in any best interest case.
You referred to Category 1, Category 2, and
Yes.
we have read the Court of Appeal judgments which seek to explain it. It is said to be a fairly porous and possibly not entirely logical distinction. Mr. Gordon, is Category 2 where parents come and say, there is an alternative course here that we would like to be taken in the interests of our
Category
son?
2 is where parents have made and been able to make a decision, but for the, I'm sorry to use this word, but I will use it, but for the interference of the court.
But any sort of decision. I mean, obviously, this is the most important and crucial decision
Yes.
in any child's existence.
Yes.
But you said this went far beyond the facts of this particular case.
Yes.
So any decision.
Would it be helpful if I just read the passage of Mr. Justice Headley, which absolutely summarises what we're saying?
We know it quite well.
It's in L.
My Lord and I know it very well.
All right, well,
we've actually cited it in several of our own judgments.
I thought that would be the case. So,
But I cannot speak for...
Well, I've read it, but I certainly couldn't claim anything like the expertise of my lady and my lord.
well, I don't want to. I obviously don't want to waste time reading it.
And it was in,
I've read the
it was
passage.
in the context of care proceedings,
Yes.
of course. And so, in a way, that's not going to help you. You've got a very big point here. It may be arguable, it may not be arguable.
Yes.
I think it's not a point that anybody has previously put before the court.
No, it isn't proved by anything Mr. Justice Headley has said. It's not proved by anything I've said. What I'm trying to submit is simply this: parental responsibility is reflected in parental decisions that parents can make. In all the justiciability cases we've been talking about, it's quite obvious that parents cannot make that decision because there is some independent force preventing them from making it. So if you are faced as a parent with a clinician saying, "I'm not going to treat your child because I do not consider it is in that child's best interest," it is ludicrous for a parent to say, "Well, I've decided you must." They can't make a decision. If you've got a local authority with joint parental authority which says, "I don't want you to do this," it's quite obvious that the parent is faced with that rock of immobility. Here, the only rock of immobility preventing the parent from making and implementing its decision is the court. That's the point. Now, if that distinction is wrong, of course, this court will say it's wrong and explain why. All I'm trying to submit is that this is a big point and it has not been decided, it is arguable, and nothing in the case law or the Court of Appeal's judgment proves, shows, illustrates that or why we're wrong.
Mr. Gordon, I'm sure it's my fault. I'm still a bit confused about Category 1, Category 2.
Yes.
I had understood it from paragraph 58 of Lord Justice McFarlane's judgment.
Yes.
Mr. Gordon submits that in a Category 1 case, the parents who oppose the course of treatment for which the treating clinicians apply do not have a viable alternative therapeutic option to put before the court. Yes. The distinction that would lead a case to be allocated to Category 2 is that a viable alternative treatment option is put forward by the parents.
That wasn't the...
in answer to me, you said, well, it's all really to do with parents who've made a decision.
Yes.
Can you explain this briefly to us?
It's not your lordship's fault. It's probably my fault for not getting this out early enough. But one of the points we make in our skeleton is that the court's recording of our Category 1-2 distinction is completely incorrect. When I went through my speaking note, which we handed into the court, 45-page speaking note, I did a Google search yesterday. There is not one reference to viable or viability. In fact, we say that viability is not a necessary finding in relation to the distinctions we seek to make. So the court picked up viability, and I can explain where they picked it up from. They picked it up from the Royal College guidelines. What they've done is to, with great respect to the Court of Appeal, they have not recorded the specific way in which we put the case. The specific way I put it is that the court, when it's faced with an adjudicatory role, has no alternative but to adjudicate. And it can only adjudicate, logically, on a best interest basis. Fully understand that. But in any other case where you have decisions taken by parents, unless there is significant harm, the parents are entitled to give effect to their decision. The determiner of whether there is significant harm, of course, will be the court. But we never put the case on, is this treatment viable? And that can be shown by the very words I put into on the court record. That speaking note has not one reference to viability.
But even if you cross out the adjective, there's still a distinction between what I've just read here and what you explain to be the difference between Categories 1 and 2.
Well, the difference, my lord, is simple. The difference between a Category 1 and 2 case is that in a Category 1 case, the court must adjudicate on a dispute between two persons which is justiciable. And where you have a dispute which is justiciable between two parties, which has to be resolved by a court, at the moment it's very difficult to think of any other yardstick than the best interest yardstick by which you would judge that dispute. But where you haven't got a legitimate dispute and you've simply got a parental decision, we say that falls wholly outside the best interest class of cases. I mean, that's the way we put it. Whether I put it less elegantly in the Court of Appeal and therefore the Court of Appeal misunderstood the way we put it, all I can say is that is how I thought I'd put it, it's what our speaking note says, and it's how I put it now.
And what's your definition? I believe I understand how you put it, and I think that's how you put it right at the outset.
That's what I think.
Yes, that there are decisions that the parents may and must make, and there are decisions which the courts may and must make, if there is a justiciable dispute.
Yes.
What is your definition of a justiciable dispute?
A dispute that occurs between two parties, which is sanctioned by, which has to be adjudicated on before the court because it is sanctioned by law or established practice. In the context of, I deliberately put those last words in because if we take a case like In Re F, where doctors wanted to sterilize, I think, a young woman and wanted the adjudication of the court, a kind of declaratory jurisdiction to validate clinical action was established. So that's a well-established practice, that kind of issue. Obviously, where you have, for example, under the Children Act, let's say joint parental responsibility, you've got law sanctioning a justiciable dispute. The point I'm getting at here is, rather than, there is simply no law that operates or established practice that operates to prevent a parent from making a decision in respect of their child in what they think is the child's best interests, other than simply taking out the whole of the law on best interests and stamping it on this area. And there is simply no law or established practice that renders such a dispute justiciable. Now, your ladyship and your lordships may say, at the end of a full hearing, if we're allowed to have a full hearing, well, as I think Lord Justice Watkins said to me many years ago about heads of public policy, we're creating it now. The court may create this. All I'm saying is it's not present at the moment. It simply doesn't exist. There is no case, and I'm quite sure one case would have come up by now if we were wrong in saying that there is no case that comes remotely near to establishing a jurisdiction in a case like this, a justiciable issue. The closest I've come to it in my own practice is the Broadmoor Special Hospital case, which is in fact what gave me in a sense, the foundation stone for this case, which I don't know if the court knows about that case, but it's a case where a Broadmoor patient wants to publish a book about his time in Broadmoor. Broadmoor doesn't want him to publish the book, so it goes for an injunction. And our position was in that case, Broadmoor has no power to seek such an injunction. Now, my basic premise in that case, that you have to have a power as a public body before you can seek an injunction, was accepted by the court. But in the event, in that particular case, two of their Lord Justices thought I was wrong about saying there was no power. Lord Justice Morritt, as he was then, found that we were right, there was no power. But the point is, the basic proposition was accepted. You don't get into a court with a supposedly legitimate dispute just by asserting that you have a claim. That doesn't create an issue. I wonder if I could come to my point 8 on your ladyship and lordship note. If the category 1 and category 2 distinction is correct for the purposes of for the purpose of a permission hearing arguably correct, this also disposes of the second difficulty identified in paragraph 6 of the note for exactly the same reason. The legal test applied by the Court of Appeal for what constituted significant harm is precisely that to be applied in a judicial best interest test. There is simply no distinction. The Royal College guidelines on which both the first respondent and the Court of Appeal relied for the significant harm argument and ruling is exclusively focused on best interests, I'll take the court to the guidelines if I need to, but that is what the reality of the decision was. And then the last point on this, if the Royal College guidelines were to be taken as the relevant touchstone for significant harm, it would produce the same effect as ignoring the Category 1 and Category 2 distinction altogether, because properly analysed, the court would, under the guise of applying a different test, be applying exactly the same test. We say, with the greatest respect, that is logically incoherent. And the very last point, which is one I've developed later, is it simply is extraordinary for the Court of Appeal to make a finding of significant harm by reference to evidence in which that question was never raised, and on a basis which was the subject of no respondent's notice in this case. Only the second respondent, the Guardian, put in a respondent's notice, but that respondent's notice was exclusively tied to the best interest balancing exercise.
But Mr. Gordon, it was you in the Court of Appeal that raised significant harm, so the Court of Appeal had to deal with it. And because it hadn't been raised before Mr. Justice Francis, he hadn't addressed it.
No, my lord, the position is this. We set out our stall very soon after I was instructed in our skeleton, and as a result of that skeleton argument, which raised significant harm, the second respondent, the Guardian, put in a respondent's notice, but not addressing significant harm, addressing only best interests. So our point is that there was plenty of time to put a respondent's notice in, saying to the Court of Appeal, you should decide this case on significant harm. There was no such respondent's notice. And so we were very surprised because it seems to us that the very convention protections inherent in every single convention right ought to militate against such a process. It's true, it's quite true, the point was only raised in the Court of Appeal, but there was no indication from the respondents in any respondent's notice that the judge's judgment was going to be argued to be upheld on a significant harm basis. There was all sorts of arguments in the skeleton arguments about significant harm, but that's not the same thing. So, although that's a procedural point, and it's slightly out, for the moment, hopefully outside the thrust of a permission hearing analysis, it is a point we will, if given permission, want to raise. So there are propositions, and now we can apply them to the Court of Appeal judgment, and I can go through the...
Well, Mr. Gordon, as you're aware, you're already well over.
Yes, I know, Madam.
Half an hour is for the whole hearing, not just for you.
I know.
I think you've had 3/4 of an hour at the very least.
Yes.
So would you be kind enough just to wrap up as quickly as you can?
Well, in which case, my lady, there's not a lot more to say. The basic point is that had I had more time, I would have simply developed the grounds of appeal by reference to the Court of Appeal judgment. And
that is not, in a sense, something for a permission hearing.
I'm grateful, my lady. In which case, I won't take up more of the court's time. I'm very grateful.
Thank you. Ms. Gollop.
The suggestion seems to be that parents always know best, that they are Caesar and the child belongs unto Caesar, and there is no one, therefore, to whom the child needs to be rendered, and moreover, that the parents will decide when the court has jurisdiction. So the parents are elevated to be judge, perhaps the font of jurisprudence almost, the determiners of what is and isn't justiciable, the sole and only determiners of what can happen to the child that belongs to them. The child has no voice because the child needs no voice, because they are the sole guardians of any matter that needs to be considered in relation to the child. It seems a power without end, almost, the way that it is put. It is dangerous. What happened here is that there arose, very unfortunately, between the hospital and the parents, a dispute that couldn't be resolved about the child's welfare. The case is particularly sad and particularly difficult for all of those who care about Charlie, but I hope I do him and his parents no disservice if I say that it is not unusual. It is very regrettable that there are children, and often they are in the care of specialist children's hospitals, whose conditions we cannot cure and whose conditions we cannot ameliorate. That doesn't mean that everybody agrees on the way forward. And it happens very often that the parents of such a child want desperately to do just as these parents wish, which is not to look back and think that there might have been something that they could do for their child that they have left undone. It isn't, in that sense, an exceptional case, and these cases are determined very regularly. When we were in the Court of Appeal, the case was in part determined by Lady Justice King, who had decided a very similar case less than a year before, the case of Rie, which is set out and mentioned in Lord Justice McFarlane's decision. They are determined according to the paramount interest, which is the welfare of the child. What the parents want to do is remove the child from that jurisdiction, and they will determine what is best. When this point was put to Mr. Gordon in the Court of Appeal, he said that the child needed no separate voice because the parents would speak for the child. That is against so many laws. I was surprised to hear Mr. Gordon say that there is here no sanctioning of law. When he identified what he now says is a Category 1 case, he said it was a dispute between two parties that has to be adjudicated because it must be sanctioned by law or well-established practice. There is, as my Lady Justice Hale mentioned in paragraph 3 of the provisional views, the Children Act 1989, section 1, subsection 1. There is the Human Rights Act. There is Article 3 of the UN Convention on the Rights of the Child, which says all actions concerning children, whether undertaken by public or private social welfare institutions, which must, above all things, include a children's hospital, courts of law, administrative authorities or legislative bodies, the best interests of the child shall be a primary consideration. Best interests and welfare are coterminous. There is no Category 1 and Category 2. Best interests and the inherent jurisdiction of the court are the broadest, widest, most flexible jurisdiction that can take into account all aspects of welfare, medical, emotional, spiritual, all aspects which we can imagine and can't imagine. It's a jurisdiction which contains all the multitudes necessary, that balances all rights and protects all rights, but puts at the heart of the decision the paramount interest, which is the welfare of the child. The point of general public importance, which it is said that there is here, is that that should be swept aside in favour of the rights of the parents, apparently under Article 8, which trump all. Mr. Gordon says under Article 8, quote, parents lose all rights. That isn't so, it's everybody else who loses their rights. The child who loses all rights. It isn't that the state intrudes on a massive scale, it would be that there is a zone in which the state intrudes not at all and has no aegis under which to protect some of the most vulnerable in society. It's difficult to imagine a more vulnerable person than Charlie.
Is every case justiciable where there is a debate to be had as to whether the discharge of parental responsibility might not be in the best interest of the child?
I think the answer to that must be yes, every case is justiciable, where the best interests of the child, the welfare of the child, are engaged. There must be perhaps some issues that are de minimis, perhaps, where a court would say this isn't a matter for the court to decide, it isn't serious enough. But that isn't this case, which couldn't be more serious. And if the best interests are engaged because the welfare of the child is potentially at risk, then I struggle to think that there is a case which is outside the jurisdiction. I want to say a word, if I may, about the actions that were taken by the hospital and how that came about. When the application was made, the parents were unrepresented. They didn't have any lawyers. The hospital had known for a long time that there was a dispute between what they felt was the way forward and what the parents felt was the way forward, and it was clear that that was not a dispute that was capable of being resolved. And the dispute was very, very straightforward. There were two ways forward, and they had come to the fork in the road because those two roads went off in completely divergent directions for Charlie. One was that the treatment that the parents wanted him to have was in the consideration of the hospital after a great deal of thought and as a result of a clinical change in Charlie's condition around about December, January time, which meant that in the hospital's view, his brain had become so damaged that treatment, the NBT treatment, couldn't reverse or ameliorate that or provide Charlie with a life that was going to provide him with any benefit. That treatment should not be given, and that palliative treatment was the only treatment that was in his best interests. Going right off in the other direction, the parents felt very strongly that the treatment would work, and they continue to hold that view, and they've been on national television very recently saying they think it will work and they want to try it, and it is their perfect right to hold that wish on behalf of their child. There isn't a third way, and the only way to resolve the dispute was to bring it before the court. There isn't anybody else that can be the decision maker. The parents have said that they feel that the hospital is holding Charlie a prisoner, and they have said that they feel that when they took Charlie into the hospital, they were stripped of their parental rights. One can understand how they feel that way, but neither of those statements is true as a fact. The hospital has tried to work with them and has listened very intently to everything they have to say. The hospital sought a large number of second opinions before it made the application from up and down the country. There was a hospital in a European country that declined to take Charlie because they felt that the treatment NBT would be futile. So it is not as if the application was made without consideration. As I say, at the time that the application was issued, the parents didn't have lawyers. And so there were a number of different ways in which the declarations sought could have been drafted. I drafted them, and it seemed to me to be totally wrong, unfair to the parents, unfair to the court, to put one path at the fork in the road before the court, but not the other. These sorts of proceedings are inquisitorial, they're not adversarial, but on the other hand, I didn't think one could very well draft the declarations in such a way as to simply say, Judge, we throw it all up in the air and it's for you to disentangle and sort out. So since it was the hospital's application, I set out the declarations that the hospital would seek so that it could be clear to everybody not only what was in Charlie's best interests, but what was not in his best interests. And that is the reason why the fourth declaration was included, that it was not in his best interest to undergo NBT, so that there could be no doubt about it, and that anybody who might have care of Charlie in the future would know what the court's determination was. And that is how the application came to be made. It wasn't done in order to have the effect of holding Charlie a prisoner within the confines of Great Ormond Street. And to put it in that way it's simply not what happened, nor what was intended. What was asked for from the court was, as I say, a best interest determination that set out what was and what wasn't in the child's best interest, so that both sides of the coin could be looked at, rather than just one coin, one side of it, which was palliative care, without looking at the alternative. Mr. Gordon says that there has never been a case like this before the courts before, and that is wrong. Can I very briefly ask you to look at the Court of Appeal's decision and that of Lord Justice McFarlane, which you have at tab 5, at page 43 and 44.
Which bundle?
It's the appeal bundle, Richard, the one with the Court of Appeal's decision in it.
Appeal bundle.
In the quotation at the top, there is a sizable quotation from the case of Rezed, with which I know you will be very familiar, and the judgment of Sir Thomas Byng and then the Master of the Rolls in 1997. The proposition there was essentially the proposition which is the same advanced by Mr. Gordon on behalf of Charlie's parents. And he says at the top, this is the quotation, "I understood the Mother's Counsel to advance two reasons why discretion could only be properly exercised to the effect contended for. The first was that the court should never override the decision," I stress that word since that's what Mr. Gordon says makes this case unique, "the decision of a devoted and reasonable parent such as this mother was found to be." And he went on to explain why that was not so. And he concluded by saying, once the jurisdiction of the court is invoked, its clear duty is to reach and express the best judgment that it can. And then Re T, another 1997 case, Justice Butler-Schloss quoted that case, and then in the second paragraph, quoted in paragraph 91, applying those principles to the first case, the first argument of counsel that the court should not interfere with the reasonable decision of a parent is not one we are able to entertain, even if we wish to do so. And she went on to say that that is an attempt to import into the jurisdiction the test applied in adoption, effectively the significant harm test, which is now being contended for. It's not right to say that there's something special about this case because there is a treatment alternative. The category 1-2 thing is, I find it difficult to understand, and it's partly because the definition shifts and changes. There's no definition of significant harm. Mr. Gordon takes the Court of Appeal to task for failing to define it, and I quoted to you Riel, a case which he relies upon, where it was said that there are good reasons for not seeking to define significant harm, perhaps similarly, and for not dissimilar reasons to why it's sensible not to try to define best interests or welfare. It was quite reasonable, I think, for the Court of Appeal to get what he now says is the wrong end of the stick by saying that they had understood a Category 2 case to be where the parents have made a decision to give to their child a viable treatment alternative, because it would be quite odd, in a sense, to want to give to your child an unviable treatment alternative. The reason why this case is here is because fundamentally the parents do not accept the facts which have been found at first instance and reaffirmed by the Court of Appeal. They simply don't accept that NBT will be futile. So what is contended for here is that parents have a right which the courts cannot touch, and the doctors cannot bring before the courts, and the courts, even if the doctors do bring it before the courts, have to say we have no jurisdiction to hear it, which is to subject their child to a treatment that won't work, no matter what the consequences of that or however long it may last. Now, they say it matters not in this case because the only known side effect of the treatment is diarrhea. And I pause there and say, we really don't know if that is the only side effect, because the treatment has never been tried on an animal, and it's with this condition, and it's never been tried on a human being. There is at least the possibility of other side effects. But the point is, on behalf of Charlie, we simply don't know. The other point is, and the point that was important to Mr. Justice Francis and important to a unanimous panel of the Court of Appeal, is that the treatment takes time. And over the weeks and months that it is administered, Charlie must be forced to exist in his present parlous condition. That is the adjective used by one of those doctors who examined him for an independent second opinion. The reality is that Charlie can't see, he can't hear, he can't move, he can't cry, he can't swallow. He has a machine that causes his lungs to go up and down because he cannot move his lungs up and down, and therefore he is ventilated in that way. His is a condition that the judge found, having visited him at hospital and having spoken and heard from those who treat him, the doctors and the nurses, having read all of the second opinions of all of those doctors who have been to visit him. The doctor in America is alone in those who've provided evidence to the court in not having examined Charlie. That, immensely sadly, his condition is one that affords him no benefit. To say that to be kept in that condition whilst a futile treatment is tried over months is not a significant harm is an extraordinary submission.
Does he suffer pain? Does anybody know whether he suffers pain?
We don't know.
Is ventilation by itself something which does or does not inflict pain?
The current ventilation, which is done by a machine, I think there is no evidence that it causes any pain. There has been in the past, and if Charlie's life were to be prolonged, perhaps would be in the future, talk of changing the way in which he receives, he's oxygenated by a tracheostomy. And there was evidence by some that having a tracheostomy which would require suctioning in order to keep the tube patent, that suctioning does cause pain. We know that it causes pain, and we know this from patients who've undergone the experience in intensive care and then recovered consciousness and been able to tell us about what it felt like at the time. We know that to those who have awareness and the ability to experience pain, that it is painful. But I don't want to mislead this court, and we simply don't know if Charlie has that level of awareness or that experience of pain. Some of those who gave evidence to the judge who look after Charlie felt that he does suffer and he does experience pain. Others felt that he did not. And I think the logically right and rigorous position is to say that we simply do not know. To go on from there and to say that because we do not know, ergo, there is no significant harm to keeping him alive whilst he undergoes a futile treatment, is, I would suggest, a step too far. It's not the logic of Bland or the logic of Aintree. We have put in quite extensive written arguments, as you will have seen, and I think that there is nothing more than that I want to say to you, unless I can assist you further, but I will check with my junior, who knows as much as I do. Thank you very much.
Thank you very much indeed, Miss Gollop. Ms Butler-Cole.
My Lady and my Lords, my Lady and my Lords have the brief written submissions on behalf of the Guardian. There are just a very few matters which I would like to address my Lady and my Lords on, if I may. The Guardian's primary concern, as set out in the written submissions, is that whatever the merits or otherwise of innovative legal arguments in this case, they're not going to make a difference to Charlie. And the problem is that if one takes the appellant's arguments at their highest, and one understands the distinction between Category 1 and Category 2 cases, which, as I understand it, is a distinction between cases where consent is required from the court because there is no one else willing to give it in a Category 1 case, from a Category 2 case where consent isn't required from the court because there's a treatment which parents are consenting to and someone willing to provide it. So that need to get consent from another source doesn't arise. If one takes that category as being a valuable, that distinction as being a valuable one, and then considers it in relation to the case of Charlie, it must be right that a treating hospital such as Great Ormond Street are allowed to bring the matter to court to ask whether the significant harm threshold has been crossed, given that, as in this case, they had not just a difference of views about best interests, but the concern was that it would be unethical for Charlie to receive the treatment in America. It must be right that they can ask the court, has the significant harm threshold been crossed? The court then would have looked at the same issues that it did look at in the proceedings constituted as they were in the usual way in relation to best interests. It would have asked itself a different question, has the significant harm threshold been crossed? But of my submission, it's obviously correct, as Lord Justice McFarlane found, that it would have come to the same conclusion. And that's because whatever the threshold is, if there is a threshold, it must be right that the provision of futile treatment to a child who's experiencing pain is not something which can be sanctioned. And that's the fundamental difficulty with the argument, is that for Charlie, even if it's right, it doesn't make any difference. My lady asked about the question of pain, and just for the court's reference, Mr. Justice Francis, in the judgment at first instance, which is tab 13, summarises his findings at paragraph 113, which is page 25. And notes that no one can be certain about whether Charlie can feel pain, and that's because of his severe muscle weakness and his severe brain damage. He doesn't make the same responses to pain that other people do, and so one can't be certain whether what looks like a pain response, for example, an increased pulse rate or something of that sort, is actually a conscious experience of pain. But the judge sets out and accepts the views of Professor A, that paragraph 114, that on balance that Charlie was likely to have a conscious experience of pain, and that it was her view was that his pain was not of a low level of suffering but something more significant. But it wasn't, it's clearly not just that question of pain. It's the question of the futility of the proposed treatment that Miss Justice Francis and then subsequently the Court of Appeal thought was so critical. So that is really the concern, that even if one takes this argument at its highest, gives the benefit of the doubt to the appellants, says that yes, there is a threshold, yes, when applying that threshold, the test is significant harm. The problem is that none of that would change the outcome for Charlie. And the Guardian doesn't share the concerns that have been set out that this represents state intrusion on a massive scale. The best interests approach has been applied for decades by the courts, and there aren't any cases, as has been pointed out, of this sort. Now, that's either because doctors are routinely overriding treatment decisions that parents are making but not coming to court to obtain a sanction for that, or is more likely is that in the same way that the courts give great respect to the wishes of parents where there are treatment options available, so do doctors. And in my submission, it's completely clear that the best interest test is capable of that nuanced approach and application by the courts. And in this very case, the Guardian set out only a provisional view prior to hearing the oral evidence in relation to nucleoside therapy, precisely because if there was a chance that the treatment would be of meaningful benefit to Charlie, then it might well have been in his best interest for him to go to America and receive it. Unfortunately, having heard all the oral evidence, that was not the Guardian's view, and nor was it the view of Mr. Justice Francis.
Thank you very much, Ms. Bradford. Mr. Gordon, would you like to come back for a moment or two?
My lady, very briefly, yes. Ms. Gollop began her address by saying that our submissions would involve unlimited power on the part of parents. That's plainly a distortion of what we're saying. We do accept that there is a controllable, a level of control. We simply say it is not the best interest level of control. It is a significant harm level of control. Ms. Gollop said that we were ignoring Article 8 and the children's rights and super-elevating the parents' rights. I hope that I have laid sufficient stress at the beginning of my address to your lordships on the fundamental point that parents don't have rights in this context, they have responsibilities. The question is really who decides. That is the legal question at the heart of this. My learned friend, Ms. Gollop, in answer to a question from a Lord Kerr, said, and she, as I think she had to say on the logic of her argument, every case must be justiciable. That's where we differ, and that is the point of principle in the case. I mean, that's the whole point. My learned friend appeared to say that this case was purely a question of the framing of a declaration. There was no question of restraining, of restraint intended. I thought that was her submission. If that is her submission, I would just refer this court to Supplemental Transcript Bundle, tab 3, at page 68. Because this exchange between the court, the judge, counsel representing the first respondent, is quite illuminating.
Sorry, would you just give me that reference again?
My Lord, yes, it's the Supplemental Transcript Bundle. It's tab 3. This is part of the hearing on the 5th of April of this year. And it's page 68 on the internal numbering. And we can pick it up from the first reference to the learned judge, Mr. Justice Francis, at page 68.
68.
68.
Thank you.
He says, I do not think the issues are going to be determinative. I was, however, concerned to hear Miss Yates, Miss Yates, that's the mother, saying, and this is my note, and you can tell me if my note is correct or not, I didn't know about their application, for which I, this is Mr. Justice Francis, put in brackets about stopping them going to America until I spoke to that journalist lady. That's something which I suspect you wouldn't agree with. No, indeed, without wishing to trespass into submissions, my lord, the witness went on to say, she said, I had to show her what the hospital was saying. My impression, I can ask Miss Yates about it, is that she showed the journalist the documentation that was the application. And then over the page, I suppose right down at the bottom of the page, Miss Powell, line 33, So you had that, you sent it to the journalist, and did the journalist explain what it meant? I actually contacted the journalist and said, I'd like potentially to go to the media with Great Ormond Street saying we can have this treatment, we have to have it in America, so can we do it together? She said, no, you can't do that. So, because Great Ormond Street aren't saying that, they're saying you can't go. Question, all right, so it was not the journalist who informed you as such, it is the journalist who helped you to understand what the application notice meant. Is that right? And then Mr. Justice Francis over the page says that clears up the misunderstanding, I think, said that is as far it is a matter for you. So what appears to be being stated here is that the mother had only just learned that that was the purpose of the application, and what was clarified in cross-examination was, well, the journalist helped me to understand what we were applying for. That's how I read it. So, without wishing to be critical, there is no doubt that as this hearing progressed, whatever was the beginning of the hearing, it did become a hearing in which the mother was told, if she hadn't understood it, that this application was to stop her going to America. And we say that that is what strays beyond the area of justiciability. The fourth point made by my learned friend Miss Gollop was in relation to Re Z and Re T. The simple point about Re Z was that no question of justiciability was raised, so this point that we're raising was never considered. Re T is a classic Category 1 case. On the question of pain, Ms. Gollop was fair about that. And
What made Re T? I suppose that's because that was a case in which the hospital wanted to treat and the parents didn't want them to
Exactly.
treat. That was Re T, wasn't
exactly,
it? Yes.
Exactly. The Guardian hasn't, with respect, added a lot. But what the Guardian's main point seems to be, well, nothing would change the outcome. That's because the Guardian latches on to the word futile. But as your ladyship said, I think, in the Aintree case, futility may not just be a therapeutic concept, it has wider connotations. And so we don't regard ultimate difference in the outcome as determinative here. What we say is this decision by the parents is well within the range of decision-making that a parent might be thought not unreasonably to make. The fact that reasonable wishes are necessarily overridden in a Category 1 case does not mean that they can permissibly be overridden in a Category 2 case. And our argument is as simple as that. We say it is a very big and important point. We say it is definitely arguable. We also say, with respect to both of the respondents, that neither of them has raised a point of principle as to why they are wrong. Those are our submissions.
Thank you very much indeed, Mr. Gordon, and to everybody who has addressed us and for all the written arguments. We will retire now and we will hope to be in a position to give you a decision later this afternoon.
Very grateful.